lords, to this whole morality issue, which I do want to disabuse my lords of. But I just want to point out Article 33 so that it becomes clear that there is also, my lords, a lot of case law on Article 33, which at a later stage I will refer to. But, my lords, insofar as the armed forces are concerned, they are a class apart. They are a class apart. So even, my lords, on moral standards relating to other matters, there is a different set of standards which is expected of the armed forces. Please see.
Yes.
Well, of the Constitution, Article 33. Power of Parliament Power of Parliament to modify the rights conferred by this part in their application to forces, etc. Parliament may by law determine to what extent any of the rights conferred by this part shall, in their application to A, the members of the armed forces or the members of the forces charged with the maintenance of public order or persons employed in any bureau or other organization established by the state for purposes of intelligence or counterintelligence, or person employed in or in connection with the telecommunication systems set up for the purpose of any force, bureau, or organization referred to in clauses A to C, be restricted or abrogated. My lord, please note these words. So, my lords, fundamental rights can be restricted or abrogated so as to ensure the proper discharge of their duties and the maintenance of discipline among them. Now, this has been interpreted, my lords, several judgments. I will show that at a later stage. But let me, my lords, at least now elaborate on what Joseph Shine was about. What is that context? What are we concerned with? And is the compelling state object the same over here? Does it not require a clarification which will put to rest, because it is impeding our ability to take disciplinary action within the armed forces? It impacts our security concerns. And therefore, my lord, to ensure proper discharge of duties. Now, my lords, so therefore, my lords, this was just to mention it at the outset that ultimately this is a class apart. The case law is very well settled. Armed forces, they form a class apart. And there is, my lord, fundamental rights can be restricted. My lord, they are restricted. Even the right to privacy is restricted for ordinary civilians. But apart from those restrictions, there are other restrictions which apply because of, you know, the nature of their duties, very simply.
Why can't you take us through the objects and reasons of the Army Act also? It has some
May I do that?
Please go through.
Certainly. I'm grateful.
Especially after 15th August 1947.
Yes, this came in 1950. Yes. Lords, may I read the SOR, the Army Act? Statement of objects and reasons. The need for a general revision of the three acts, namely the Indian Army Act 1911, the Indian Navy Discipline Act 1934, and the Indian Air Force Act 1932, has been felt for some time past. Some of the provisions of the existing acts were already coming out of date and insufficient for modern requirements, but after 15th August 1947, the need for revision became imperative for obvious reasons. It was therefore decided to revise all the three acts with a view to making them self-sufficient and complete codes in themselves. I'm so grateful to my lord. The object was to make them as closely similar in form and arrangement of matter as the special requirements of each service might demand. Although the revision of the Army and the Air Force Acts has been completed, this has not been possible in the case of the Naval Act. The present naval
Only the first portion, that is the main thing.
Yes. Well, self-contained code, your lordships are absolutely right. And in fact, when we discipline for good order and for military discipline, it is a form of self-regulation where only the armed forces can completely appreciate and understand what can lead to a trigger which can be a breach of military discipline, which can impact security. And therefore, it is a self-contained code. This is self-regulation at a certain level. My lords. Now, my lords, just coming to just a preface which I want to make to Joseph Schein, what Joseph Schein dealt with. And then, my lords, I will explain the morality and the standards aspect insofar as, my lord, the armed forces are concerned. My lord, may I preface my arguments insofar as Joseph Schein is concerned by saying two things broadly. One is that, my lords, the court was concerned with a peculiarly worded provision where the court was really looking at it in the context of the institution of marriage. The important thing that I want to say here, my lords, is that the court was not concerned. It was not concerned with the impact of an extramarital relationship in the context of a workplace or a work culture. And certainly not in the context of a work culture as unique as the armed forces. So my lord, Joseph Schein was in the context of the institution of marriage and not in the context of a work culture. Two, my lords, the compelling state interest, which eventually led to the striking down of 497, was that it was not only concerned with preserving marriage, and therefore it could not be criminalized. It was recognized as a wrong. It was recognized as deception, etc., as a ground for divorce. That all that the court preserved. But what it said was that ultimately this is patriarchal. It is out of sync with the times. And the idea, the object, the compelling state interest was not only preservation of the institution of marriage, but to preserve and to control the sexuality of a wife so as to preserve the purity of the bloodline. That was as, my lord, archaic as the provision was. It was in the, my lord, 1800, and that's what Justice Chandrachud actually observes in that the idea was to preserve the purity of the bloodline and therefore control the wife. So, my lords, this is not the prism that we are concerned with. Our compelling state interest is going to be military discipline. Of course, I will show how it can both really and potentially impact military discipline. That I will show. But, my lords, that is what I want to just preface Joseph Schein by saying. And ultimately, my lords, what the court found, that this is 497 is such an illogically framed provision, because the wife of my lord, the adultering man, she cannot be an aggrieved person. She could not, the wife of the man who was involved in the adulterous relationship could not be an aggrieved person. My lord, the wife who was actually involved in the adulterous relationship, she was not even an abettor. She could not be an abettor either. It was the man, the so-called adulterous man, who was the perpetrator. He was the seducer, etc., etc. And it was only her husband who could complain, because he was the aggrieved person, because the wife was his property, his chattel, etc. And he had the right to control her. So, my lord, we were concerned there with a very peculiarly structured provision, very utterly patriarchal. But, my lords, apart from this, it being completely gender, in fact, anathema to gender equality, there was another aspect which is also tied up with this, that the court recognized that there is a right, a fundamental right to privacy that both men and women enjoy. And my lords, I will be pointing out that there was a slightly, perhaps a discordant note at a certain level between two opinions, which, my lord, I certainly see. And which is that, my lord, one opinion seems to suggest that there is privacy both within marriage, the right to sexual choices within marriage, as well as outside of that relationship with a third party as well. That is what one of the judgments certainly seems to suggest. So, my lords, whether this will also be used, because that is also being used as this is our right to privacy, even to have an extramarital affair. Whereas another of the opinion, Justice Malhotra's opinion, my lords, says that no, you do not enjoy Article 21 protection for the purposes of an adulterous relationship. So, my lord, there is a little bit of a discord there. But eventually, my lord, there are observations which seem to suggest that in no situation other than those which have been identified can any such conduct within or outside of marriage be criminalized. So what is therefore a criminal offense? What do you need to show in order to criminalize something? There has to be a societal interest, etc. And the court seems to find at paragraph 58, which I'll show your lordship, that only in these situations can you criminalize, which includes, my lord, for instance, domestic violence or dowry, etc. But therefore, the question arises then, my lord, the armed forces, that was never an issue. In fact, no workspace or no fallout of an extramarital relationship